All right, so we'll get started. It's a little bit after 2 o'clock. The meeting of the Access Justice Commission, and we have people appearing remotely, and it's also being streamed live, and people can appear or log into watch the proceedings. All right, so the first order of business is the review and approval of the minutes of January 9th that were sent to all the commission members. Is there a motion to take through the minutes?
So moved.
All right. Spader, is there a second? EJ, any discussion? Seeing none, all those in favor of approving the minutes say aye.
Aye.
Any opposed? I don't think Moy was opposing. I think it was an aye, right? And any abstentions? Right, the minutes are approved. We're going to take things out of order. We're going to jump right to the one update from Judge Thomas of Legal Aid Subcommittee, because he's in the middle of doing a trial, and I want to make sure he's able to get back to his trial. So, Judge Thomas.
Thank you, Justice Bright, for that opportunity, and sorry for.
Can't hear you.
Can you hear me okay?
Hold on 1 second.
Can you hear me now?
Again,
Go ahead.
Okay. Thank you, Justice Bright, for.
Now,
can someone else
hear you.
speaking, please? That's remote.
What was that?
Can someone else who's remote try speaking? Boy, you want
Can
to
you
try?
hear me?
Hello?
This is Ed Heath.
No, can't hear you.
Can you hear Moy?
Testing, 1, 2, 3.
Can you hear us?
Those of us, I think, who videoed in and dialed in can hear those of us who videoed in and dialed in, but not the other way around.
Yeah, for what it's worth, I can hear both Moy and Judge Thomas.
Okay, we got you now.
I can as
Okay,
well.
Okay.
Okay, all right. Go ahead, Judge Thomas.
Can you hear me now?
Yes.
Okay, good to see everyone. And thank you, Justice Bright, for allowing me to present out of order. The Legal Aid Subcommittee last held its meeting on March 14th, 2025. We were lucky to have with us a guest speaker, Samira Nizam, from the National Center for State Courts. She presented on her reimagining, or the National Center for State Courts report, Reimagining Housing Court, a framework for court-based eviction diversion. We've added to our subcommittee a number of additional representatives from our legal aid programs, as well as Bill Pitt, who is the chief clerk for housing. And so we had a fulsome discussion after Attorney Nizam's presentation on the work that they've seen across the country in working with different jurisdictions, different housing courts across the country to implement in 2 cohorts eviction diversion programs. Broadly, eviction diversion programs are court-based programs in which a variety of stakeholders meet together at the court at that point of intersection between the landlord, the tenant, and the court system to try to find alternatives to obviously resolution by judicial decision. Obviously, here in Connecticut, we have a very successful mediation program that has a positive rate of success, but these programs oftentimes bring other stakeholders into the courts. So oftentimes that's community agencies that are offering resource support, financial counseling, financial assistance to allow for resolution of disputes in the eviction context, and other supportive services. Sometimes that takes the form of assistance with moving, or other assistance necessary to either put the situation back together or to allow for an appropriate transition. And so the 2 cohorts that have been through, I think, the first round and is in their had completed their cycle. There was a second cohort that is in the middle of their cycle, but the overall data and reports from these eviction diversion programs is heartening. That some 89% of the cases that engaged with the diversion program resulted in a settlement agreement or voluntary dismissal. And so the question here is, could our subcommittee begin the process of thinking about what such a program would look like, creating the intersection between housing code enforcement, perhaps community agencies that offer financial assistance or rental assistance, as well as other perhaps financial counseling offered as part of the mediation program, perhaps over a longer period of time than the typical current practice of having mediation on the day of trial. And the question is, where would we design that? How would we design that? And what rules or statutes would we need to consider if we were to implement such a program, even on a pilot basis in one of our housing courts or housing sessions. We also are focusing our efforts on the possibility of looking at the creation of a pro bono academy and perhaps taking a look at the MCLE rules related to mandatory CLE within the first year of practice. So there is a proposal that's working its way through the MCLE Commission and maybe to the Rules Committee regarding credit for pro bono work, or credit for MCLE, sorry, if an attorney performs pro bono work. Related to that, we have presented to our committee, and this will be discussed further in subcommittee meetings in the future, a concept in which in the first year of practice or the first year of admission, new admittees to the Connecticut bar would be required to take additional CLE in professionalism and in the provision of pro bono work, with a real focus on ensuring that new admittees understand precisely what pro bono means in the context of Rule 6.1, but also are provided with sort of nuts and bolts instruction, education, training on how to engage in meeting the civil legal access to justice gap here in Connecticut. And so this would build on prior efforts that have been done in other contexts. It certainly would hopefully not require any of our legal aid provider members to recreate the wheel, so to speak. But if we could, in our hopes, make this a new tradition, even if it doesn't automatically become a rule, if it's simply at the outset, a standard program that's offered within a month or two of every admission ceremony, perhaps that's a good opportunity to begin to think about changing culture around pro bono or improving culture around pro bono and equipping young lawyers with the tools necessary to actually provide that work in eviction, consumer, family cases, areas of greatest civil legal need. Our next meeting will likely take place in early May. And that's where I hope we'll really drill into some of these concepts and begin to put some more detail on them. So more to come from our subcommittee at future meetings. And thank you all for allowing me to present out of order so I can get back to my trial. So any questions for me?
Any of the other committee members have anything they want to add to what Judge Thomas said? So thank you, Judge Thomas. I'll just say, so he hears this when he's gone back. I was going to mention it to all the subcommittees that my hope would be that as you continue your work, that maybe by the fall when we meet in September or October, each of the committees would be in a position to say, all right, this is what we want to focus on, and this is what we want to present when we do the Access to Justice conference a year from now. So if you're thinking of kind of your timelines and putting things together, that's what I'd ask you to think about for planning purposes. Okay. Thanks, Cecil. Good luck with the trial.
Thank you all.
Okay. So we'll come back to the rest of the subcommittees when we get to them on the agenda, but I wanted to go back to the second item on the agenda, which is the presentation from Jen Shukla. Are you still working on it?
We are having some technical difficulties at the
Okay.
moment. I
Okay.
might need a minute or two. There's something else we could.
Yeah, if you want to work on that, we can go to the next item on the agenda, which is the proposal to the amend discovery rules in summary process matters. So let me give you a little context for this. There was a proposal made to the Rules Committee to amend the discovery rules in a couple of different ways. And Giovanna Shea is going to talk more about that from the legal aid perspective, that what motivated them to suggest the rule and what they see the benefits of that rule being. We were asked, I got an email from the Rules Committee asking for the perspective of the Access to Justice Commission that came like days after we had our last meeting. So I responded back and said, well, I can't tell you the perspective of the commission because we're not meeting again until April, and knowing what the calendar for the rules committee is, I wanted to get back to the rules committee with some information. So I talked with Judge Spader, who's been doing focusing on housing until recently for most of his judicial career, I think it's safe to say. And we talked about it, and then he and I submitted some information to the rules committee about our own views of the proposed rules and whether they presented access to justice issues. And we kind of said we didn't really see it as an access to justice matter and expressed our own views on that. The branch has, independent of what Judge Spader and I were doing, has its own position, and Chief Housing Clerk Frank Pitt is going to talk about that. But I want to first let Attorney Shea go ahead and talk about the genesis of the proposal and why you do think we should be thinking about it from an access to justice standpoint.
Thank you so much, Justice Bright, and thank you for allowing me to present. For those who haven't seen it, there is a fact sheet on the proposal that I just put into the chat. So I think many of you are familiar with the proposal. As Justice Bright said, there's two parts to it. One would assist unrepresented tenants even more than folks with right to counsel lawyers, and that would be mandatory disclosure of lease and ledger before the parties went forward with mediation or trial. The other proposal is to shorten the time period for responding or objecting to discovery requests, interrogatories, and requests for production from the typical 60 days, general 60 days, to 15 to accommodate the compressed, shortened timeframe in summary process, which most of you know it's a 3-day pleading schedule, and most of these cases are completed in under 60 days. I think it's upwards of 75% are completed in under 60 days, and more than 40 in about 30 days. So I'll say this proposal is from 6 legal services organizations and attorney Jeff Genties, who works with the Yale Law Clinic. The 6 legal services organizations, many of them are right to counsel providers, but have represented folks in evictions for decades. And from our perspective, as people who work representing individual tenants, and I will also say we would gladly accept a friendly amendment for this rule to make clear that it applies only to residential evictions and not commercial. From our perspective, this information is really essential for informed decision-making by tenants. We are aware that many in the branch feel that, there's a very successful mediation program, which is true. There's a feeling that there isn't a problem in reaching agreements. But our view, working with tenants in the hallway, representing folks, seeing them when they come in on auditas, and also watching self-rep tenants in court, is that we're trying to address an information asymmetry. We're trying to ensure that there is a certain minimal amount of information that we think are critical in eviction cases. I'm also aware that some folks feel that lease and ledger are not necessary in every type of eviction case, depending on the basis for claimed in the eviction, the grounds for the eviction. But as lawyers for tenants, we know, and you all know, most of these cases are resolved in mediated agreements by folks like Attorney Claxton acting as mediators. And to get reinstated, our clients will have to pay the arrearage, make an agreement about that. And also likely, if there is a provision in the lease, the plaintiff's attorneys' costs and legal fees. And so for that reason, in most every case, no matter what the grounds for the eviction, we really want to see the lease and the ledger to really be able to understand, how are payments allocated? Are all payments recorded? Were there third-party payments made for which there might be certain conditions? And with respect to the lease, at a minimum, understanding things like the term of the lease and whether there is a provision, in fact, for attorneys' fees and costs, that kind of thing. So for us, this seems like just a very common sense measure that would not be costly, that, would benefit unrepresented tenants, that would avoid a situation that we see when people come to us facing execution and say, well, I was told, they told me in eviction that in court that I had to pay this amount to stay, that would just provide that kind of information for informed decision-making. And honestly, I think, if we were to think about certain access to justice measures like a lawyer for a day program, if I were the lawyer for the day or I was supervising them, I would really want them to have, at a minimum, the lease and ledger when they're providing brief advice to folks. I think that's really critical. So I will stop here because I think most folks are familiar with the proposal. I know that Bill Pitt has remarks on behalf of the branch, but I'm also happy to take questions at whatever juncture is appropriate. Thank you.
Giovanna, could you just address the suggested change to the 15 days for responding from?
Right. So, there's a real mismatch between the regular civil discovery timeline and the timeline for discovery and the pace of litigation and summary process, right? And of course, we can make motions under the rules to shorten that time frame, but that requires an expenditure of attorney resources and judicial resources. And the more litigation that happens, the higher the attorney's fees potentially for the plaintiff's lawyers that are then passed on to the tenants. So on some level, we feel that just a shorter default period makes sense, given how quickly these matters are resolved, how quickly they come up for trial and mandatory mediation prior to trial, same day as trial. And I think most folks here are aware, when cases are set for trial or any dispositive motion, it's mandatory for the parties to see the mediators first. And that's how most of these cases are resolved.
Okay, thank you. So, Attorney Pitt, you want to go ahead?
Thank you again for the opportunity to speak on behalf of the branch. I just want to give everyone a sense of what happens summary process right now with discovery first before commenting on the proposed changes. Discovery issues are generally rare in summary process. It's a situation where it's done outside of the pleading and the court is only becomes aware of it if there's a problem. And most of the time, if there's an issue where something is not provided, counsel will file something called a motion for stay of proceedings. And it's something that's regularly filed and it allows the court to address the situation for the particular case in need. Summary process, as Attorney Shea mentioned, has this 3-day pleading period after the initial 2-day pleading period. And it's done that way so that the matters are summary and they can get to court faster. And the clerk's office decides whether the pleadings are closed. There's no certificate of closed pleadings in summary process. So the clerk is going to have to review the file to determine whether or not it's ready for a hearing. And with the proposed change in the mandatory disclosure, that's going to require the clerks to review each file to determine whether or not it's ready for a hearing. So it's going to add more review for approximately 2/3 of all files, because most of our files do not go by way of default for failure to file an appearance. It's essentially 1/3 go by way of default. So as the proposed change is for 1312B, it states that no case shall go to mediation or trial unless the plaintiff has provided the defendant with a copy of the most recent lease, addenda, and ledger. The clerk is going to have to determine whether or not that's been provided. And I think the only way that could be determined would be if there were a notice of compliance that were filed or something like that. And that would be an additional filing in basically 2/3 of all eviction cases. Whether or not it's needed, somebody may say it's just a single piece of paper, but it's a single piece of paper in a number of files, really most of our files. And that's going to require additional court review. It's going to prevent cases that would otherwise be scheduled for a hearing right now. They would then be waiting for this. It would increase delay with the files on our dormancy list. And it's something where we think the procedure that's in place addresses the issues, which if there is a lease or a ledger that's needed, the parties can get the judges and the court's attention to address that, either through a motion for stay of proceedings or at mediation. Mediation is where everything comes to a head in summary process. Most landlords do have attorneys. It's probably 70 to 80%, but there's that other 25% that are self-reps, and the self-rep landlords and the self-rep tenants get that advantage of mediation, where a neutral party can dig into the case and determine what the arrearage is, what's going on, and give people a sense as to where their case stands and what is needed. And if a mediator sees that something's missing or something is needed before a trial can go forward, or a witness is needed, cases are generally continued to another date to address that. And most judges won't act on subpoenas right away until after mediation, because they don't want to needlessly subpoena people to come to court when the case may be settled. So I think the procedures that we have give everyone, give every file that added attention when needed, but don't require things where things are not needed. And that's the problem that I see with this. It's not that it wouldn't be useful if a lease or ledger were there. It's just requiring it in all situations is where I think as a clerk, that's where it causes the problem. Because as a clerk or somebody with judicial, we have to address all 6 sides of a Rubik's Cube. We don't just have to worry about one side, and we have to worry about the unintended consequences. And that's what worries me. I'm not afraid to work. My housing clerks are not afraid to work. Whatever happens, we will work with it and do the best that we can to ensure that the court is running as orderly as possible. But having a mandatory disclosure will add other issues. One of the issues that we have is right now for written leases, we need a written lease to show that a plaintiff would be entitled to attorney's fees. So a lot of lawyers already file written leases with the court. What they do is they upload it and they don't redact the social security numbers and the dates of birth that are written down there. So then we have to seal the entries. And I brought this as a prop. This is the whiteout that we give to pro se's at the counter to ensure that something is redacted, but there are a lot of times it's not redacted. And if we have more filings with the court, there are going to be more things for the clerks to look at, more orders for the judge to put out, and more entries that will need to be sealed. Because what lawyers will do, sure, they don't have to file it with the court, but a lot of times they may attach it to a reply to special offense or just file it as an agreement, just because what they want to do is set up a procedure that's easier for the firms to deal with. And when we have more papers that are filed, there are more things that we need to review. And when we review the same file 2 or 3 times, it will cause delay. And what we want to do is address something when we can, schedule it, and get everyone to court where that's where the magic happens. To my right is Thais Erickson, who was a mediator for years. Travis Claxton. Mediators are the people that make our courts work. They settled 90% of the cases. We would be open 24 hours a day, 7 days a week if we didn't have them. And I think unnecessarily delaying a case and pushing back that mediation is actually more of a problem. Somebody may consider it to be a waste of court time if somebody can't resolve a case on that day. But what it really does is it gets people in court to see those resources and see what's going on and get that dedicated time that they need to move forward. And I just think while there are some benefits to having Luis in the ledger, requiring it for all cases would be more problematic.
Okay, thank you. So here's what I'd like to do, and I see that Jamie and Ed both had raised their hands remotely, and I'll get to that in a second. And I want to have a discussion on this, but what I want to ask everyone to keep in mind is that we're not the Superior Court Rules Committee. We're not deciding on whether to adopt this proposed rule or not. We've been asked to comment whether we believe it's an access to justice issue. And if it is an access to justice issue, is it something where the rule promotes access to justice, or does it impede access to justice in some way? So we can talk about it. We can, if people are comfortable kind of voting today on if there's a motion to respond back to the Rules Committee for the position, or if people want more time. I don't think, given where the Rules Committee is in its cycle, that it's going to be up this year for a vote and for a public hearing. So it's going to be taken up again in the fall by the Rules Committee. So if we wanted time, we could do that. That's my understanding. Tell me if I'm wrong. Anybody, Giovanna or Judge Stewart, but
It's on rules.
This is Judge Stewart. I'm on the Rules Committee. We're done considering anything this year. There will be a public hearing in May and then a vote by the judges in June. But there will not be a regular meeting of the Rules Committee on proposals such as this until September.
So from our perspective, then, if people want more time to think about it, because this is the first time you're hearing about it, we can certainly wait until our meeting in September or October to discuss it further and take a vote. But I just wanted to give people an opportunity to comment today if they wanted to. And with that, Jamie, did you have something you wanted to say?
I just wanted to add, and it's responsive to your point, Justice Bright, that the goal of the proposal is not to inhibit settlement, mediation, and certainly not to further burden the clerk's office and the courts. But the goal is, and this is the access to justice piece of it, the connection, it's to help ensure that settlements are founded in facts and law, especially for self-represented litigants who are unlikely to have engaged in discovery. So if you're represented by a lawyer, you may have the opportunity to engage in discovery, and that is set aside that pool of people. 80 to 85%, Giovanna, I think, are we up to, have we got 85%, 15, we're up to 18%, I think, of litigants who are represented, tenants who are represented in housing court now. So we're talking about 82% of the people will not have a lawyer. So this simply is about leveling the playing field just slightly and leveling the information gap just slightly for self-represented litigants who are the majority in housing courts. We've been describing this to family members and others not in the summary process weeds in this way. We ourselves would not, and we would not advise anyone else to negotiate or settle with our credit card company or with our mortgage lender without the contract and an accounting available to us. And this is akin to that. This is akin to a self-represented litigant who is already at a disadvantage because it's in an unfamiliar court structure. They have access to the court, but access to true justice means trying to eliminate the disparity in information and resources to know how to negotiate and settle. We feel like this modest change in housing court practice would, instead of overburdening or burdening more the clerk's office and the courts, would simply require landlords and their attorneys to slightly adjust their practices, and then, which would become a matter of course. They have presumably seen the ledger and the lease, if there is one, when they have filed the complaints and made the complaint allegations. And so including that would be simply a matter of course, like these kinds of financial matters are subject to standing orders and family matters, for instance. It becomes a standard of practice that is embedded in the practice and ceases to be an additional barrier to filing a complaint. We thank you for considering that, but I just wanted to address the access to justice connection.
Thank you, Jamie. Ed, Heath?
Thank you, Judge. My question's actually been rendered moot by your comments and by Attorney Bell's comments. I was going to ask you if the precise issue before us is whether this is an access to justice issue, and that's the only thing we're here to decide or weigh in on, I should say. And then I was going to ask Attorney Shea to explain how this is an access to justice issue. It wasn't completely clear to me, but Attorney Bell did that. I mean, I support it, but I understand it's a complicated question of balancing, burdens versus benefits.
Do other people have any questions or comments that they'd like to make at this time? Ed, Shibla?
Yeah, I do see that there is an access to justice connection there very much, that when we do have parties, either landlords or tenants that aren't represented, they're certainly not familiar with even the word discovery itself. And by the time they could figure out what discovery is and figure out how to serve discovery and what it means to serve something, because you're not in a restaurant bringing something on a tray, right? Served in the legal sense is very different. It sounds like from what our legal aid team is saying is, the case would be over, it'd be done, the trial would have already happened by the time they ever even knew they could file discovery or could file a motion to ask the court to expedite the deadlines. And so I do think there's a significant access to justice component there of just making sure that people have some basic facts going into it. And just to be clear, I'm speaking personally as Jen Shukla, not on behalf of the CBA today.
Yes, no, as everybody who's here is part of a larger organization, whether it's judicial, CBA, law firms, law schools. But I think all of us speak while we're here as individuals, as members of the Access to Justice Commission, unless we say otherwise, like Attorney Pitt or Giovanna speaking on behalf of larger communities. Anybody else have any comments? Judge Spader?
And just going to what Attorney Bell just said, I mean, it does sound like a level of this is, well, we need landlord attorneys to adjust their practices. That's why I'm not really sure this is an access to justice issue. I mean, the changing the 60 to 15 days, that I don't think has any, that's just a rule and a practice area that I don't know if that's specifically an access to justice issue. But in terms of the requirement, it's not all just landlords and their attorneys. There's a lot of landlords that are not represented by attorneys that this would create an extra barrier for them. I mean, I'm not really, I don't really want to have comments on whether it's a good idea, bad idea, whatever the Rules Committee feels about it. I know I've experienced it for 5-6 years, so I have a lot of experience in this area. I just am not really sure it is an access to justice issue that's appropriate for the committee. Because I think there are some unintended consequences. I think Bill said it well when he talked about the 6 sides of the Rubik's Cube. Okay, you're trying to fix one side of the Rubik's Cube. Does that make the other side a little more difficult? And those other sides might be those self-represented parties that this might create an extra barrier for them. And look, a lot of the cases that come before the housing judges, like I said, without those mediators solving 90% of the cases, we would be working 24/7. But in a lot of those cases, there's a significant number of self-represented parties that don't have leases, don't have ledgers, and we're making decisions, based on evidence that's put before us. Okay, when's the last time you made a payment? Issues like that. People don't have ledgers in a lot of these self-represented positions, and the mediators try to get that through with the parties also, trying to work things out. If there's a problem with the stipulation, as said, one of the issues that might occur, or we want to make sure all the information is correct, there can always be motions to fix that. Parties agree on those numbers. I think it's, from my experience, it's kind of a small issue where there's problems in those agreements that I'm not sure that this would be the solution to it. I do think, as was pointed out there, it may be targeted towards certain landlords, attorneys that they want to change practices of. But is that really appropriate for the Access to Justice Commission to look at it from this perspective and weigh in on it? Because I think I'm not really sure it's an access to justice issue, personally speaking.
Judge Berger?
So I want to take completely the opposite tact on that. I think when you have an unrepresented person who is faced with a prospect that they may be evicted tomorrow, as far as I know, they will agree to anything, even with the help of the great mediators. So I don't think it requires very much for a representative landlord to be in there with both lease and ledger. And if it's a non-payment case and it's a non-represented person, they still need that lease and ledger. I think it would be helpful for a judge sitting on the bench to have a look at it. I know that I would have liked to look at it. I think it's very much an access to justice. I don't think it requires much. And I think the imaginary horrible of taking a lot of clerical time will resolve itself after folks need to know that they have to file it. There'll be a rough couple of months and then we'll all be in there. And as you look through the file, look through the military affidavit, you look through that and it will be done. I think it would be useful, and I think it's very much an access to justice because it's got to be perceived to be fair. And if people have that knowledge, I think Jamie was correct. And she said none of us would go talk to the credit card company without the ledger in front of us. So same thing here. And you might just find that the landlord has been charging all of these ridiculous prices. It's $15 and $20 and monthly late fees or whatever. So it might be useful there as well. I think it's very much an access to justice.
Other people have comments or thoughts?
Oftentimes in mediation, we try to start where we want to end, right? And the important part is accuracy, and accuracy in the figures that we try to come up with these non-final stays. Whether or not it's an access to justice issue, I think the issue is whether or not the outcomes are accurate. There are often times in mediation when we have the 12 months written down. We do April, May, June, all months, and then we say what months did you pay, what months didn't you pay. And we come up with these accurate figures based on what the tenant may say, what the landlord may say. I think it may be helpful, but not critical to the process of mediation. And again, there's a mechanism in mediation to address these issues and to hopefully secure these accurate outcomes. But whether or not these discovery requests before trial are necessary is something I kind of struggle with, and I think we're all struggling with while we have this conversation. But yeah, it would be an arduous journey for also, like Judge Bader explained, it'd be an arduous journey for self-rep landlords to come up with this, because sometimes they're rooming houses, sometimes they're month-to-month agreements. There's not always leases and ledgers, and we spend a considerable amount of time asking the right questions, eliciting the information that's necessary to come up with these outcomes in these processes. So given that individual attention, but I also think what Attorney Pitt explained is that we want to give the oil to the squeaky wheel in this situation, right? And if those things come up, there are mechanisms to continue cases so that the lease and ledger, if we see large discrepancies, can be requested so that we can get a more accurate outcome. But I think where we want to end with this, with the access to justice issue, is whether or not these outcomes are accurate. Because if they probably were accurate all the time, which I think they normally are, I don't know if the discovery issue would be an issue for the Access to Justice Commission. So that's kind of where I wanted to just give some input.
Thank you, Travis. Anyone else? Jim?
But I'm going to move that we table this discussion for the following reason. I think the issue comes down to fair justice versus access to justice. And I think the committee needs to work through much more of our agenda to determine where we fall on that spectrum. Because if we take an issue, if this is defined as fair justice as opposed to access to justice, then that opens up a whole realm of discussion. So I think we need to work through some of our initiatives and figure out where we end up on that global spectrum before we can decide this question.
All right, there's a motion to table. Is there a second?
Second.
Judge Spader? All right, any discussion? All right, all those in favor of tabling, say aye. Aye. Any opposed? Any opposed? None? Any abstentions? All right, the matter will be tabled until our September meeting. In the meantime, I'm going to ask whether there are certain statistics we can pull together, and I don't know whether they exist or not, but it might be helpful to know what the percentage of plaintiffs in this case are self-represented. And I don't know if we track at all the grounds for the action, how many are non-payment of rent versus no longer have the right to occupy the premises, the lease is expired, violation of other rules other than lease, but we can talk about that later, but it might be helpful for everyone to have this when we have that type of information when we meet again. Okay, thank you, Giovanna.
Thank you all.
Jamie, thank you, Attorney Pitt.
Thank you.
And thank you for the conversation. So we'll continue this conversation in September. Okay, so now we're going to move to a presentation from Jen Shukla from the CBA and about her portfolio and how it intersects with the access to justice and where there are opportunities for synergies.
Able to screen share? Awesome. Before I get started, though, I did want to give a chance to Lena Lee, who is our guest today, to introduce herself. She is our not so new executive director at the CBA. She started with us in January, and we are thrilled to have her there. Lena, do you want to start?
Sure. Hi, nice to meet you. My name is Lena. I'm the new executive director. I started in January. Prior to that, I was the executive director, founder of the Legal Services in New York City doing affirmative litigation in housing and fair housing laws. So I'm very familiar with these topics. I'm very excited to be here with you. And we are starting very exciting initiatives started by our president, Tim. And part of it will be to engage all members of the CBA in access to justice, starting with our 150th anniversary. And in celebration, we will be pushing for 150 minutes of service by every CBA member. So I hope that will kick off a brand new start engaging more with the community.
Hey, welcome to your new position and welcome to Connect.
Thank you.
So Justice Bright invited me just to share a little about what the CBA is currently doing in the access to justice space. I think sometimes other organizations don't realize quite how involved the CBA is with access to justice. And also, I think it just always helps for different groups, different stakeholders to know what's out there. So if someone comes to us at the CBA and we're not able to help them, maybe we know where to send them or who would be able to help them better than we can. And vice versa. If someone comes to you looking for help and they can't afford an attorney, it's good to know what options are out there. So access to justice is integral to the CBA. It's part of who we are. It's part of what we do. For a wholly different event, I actually recently had a chance to look at some of our original journal articles from back in 1875 when the CBA was started. And 150 years ago, when they started the CBA, they were talking about helping people that couldn't afford a lawyer. It's part of our CBA constitution. It's part of our CBA mission statement. Access to justice is one of our top priorities in our strategic plan. And we are super, super lucky at the CBA to have wonderful leadership support, which I say because it's true, and also because my boss and boss's boss are sitting in the room. But joking aside, we have fantastic support from our leadership for access to justice. They've shown a real commitment to access to justice, partially evidenced by the fact they created a position to focus on access to justice. That's me, and also another staff member. We do have several committees at the CBA that focus on access to justice type of issues. One is our pro bono committee. I think that's probably the better known of the two. But we also have a legal aid and public defense committee whose sort of sole focus is trying to help people that can't afford a lawyer. So they also do a lot of work in the access to justice space. So there's a number of ways that the CBA advances civil access to justice. One is we do run pro bono programs. Those are running all the time in the background, 365 days a year, to provide limited free legal assistance to people who primarily can't afford an attorney. Those programs have been growing and growing. We are now up to helping over 2,000 individuals per year through our various pro bono programs. And one thing that's nice at the CBA is we are not federally funded, which does mean that we are not subject to the same income restrictions that the legal aid organizations are. So while the legal aid organizations often have to have a hard cutoff at the poverty line or 150% of the poverty line, we can help those people who, that population who can't, who would be under the poverty guidelines, but also the people who maybe make just enough that they don't qualify for legal aid, but they still can't spend thousands and thousands and thousands of dollars on a private attorney. So we are able to help that population because we're not grant funded. A second thing that we do is we resolve lawyer-client fee disputes through free arbitrations and mediations. Those are completely free, they're confidential, they're pretty quick. Our cases are typically resolved in 4 to 6 months from filing until the end. And so we'll talk a little more about that later. We're also very active on the legislative front. The CBA is often one of the drivers or one of the big supporters of access to justice changes to the law. And we are very, very lucky because we have lots of members. I believe the number is around 8,000. So when the CBA does take position on something, that can be pretty powerful to be able to say, our 8,000 members support this. And that does convey a lot of information. And then finally, we try to raise funds for legal aid programs. Talk more about that in just a minute. Okay, so Lena already mentioned our 150th anniversary year, 150-minute challenge. Lena covered that great. I don't have much more to add other than it's going to be very exciting because we do have lots and lots of members. So if each of them do some community service or pro bono, we're going to make a big difference. Part of that, we will have a day of service where we set up in-person projects around the state to encourage more people to participate. Just want to touch on each of our standing pro bono programs quickly. So the first one is the Connecticut Free Legal Answers program. Some of you are familiar with this. I know that the courts were involved in this some years ago. Statewide Legal Services had it at one point. But that's an ABA site. That the ABA created the website, then each state has their own individual site. And there's about 42 states participating right now. Here in Connecticut, the CBA has been administering free legal answers since 2019. We are now at over 2,350 questions answered just here in Connecticut, which was pretty cool because I think last year we had set a goal that we wanted to hit 2,500 questions in the year 2025. We are sitting here on April 3rd and already pretty darn close to that goal. So we're excited about that. A lot of that growth, particularly recently, has been driven by partnerships with legal departments, in-house corporate groups, law firms, law schools. And the way that works is they can have an event where they get their team together. It's community building, people are socializing, they're networking. And while they're doing it, they can answer some questions online. This is an online, for anyone not familiar with it, it is an online question and answer website. It's entirely confidential and private. So these aren't, Google posts that anyone can go and look at. It's only the attorney and the client that can see the question. There are built-in translation services for accessibility. It is available 24/7. If an individual is laying in their bed at 3 in the morning going, oh my gosh, I can't stop thinking about this legal issue that I have. I need to do something about it. They could go on and post their question at 3 in the morning. And one of our volunteer attorneys might log on and answer it. We do address any area of civil law. It does have to be civil. We actually don't do criminal law across the board. So we do have about 90 volunteer attorneys participating, which means we have a lot of different subject areas that our attorneys know stuff about. So just about any civil legal question, we've probably got someone that knows something about it. It's kind of small. I apologize. I don't know if you can see that little banner over to the side there. But I did want to mention, if you are referring people to Connecticut Free Legal Answers, a couple things to keep in mind. That program, because it is part of a federal program, is income limited. So It's not the strict legal aid limit. It's 250% of the federal poverty guidelines, but there is that income limit. And then secondly, we can only help individuals. So it can't be corporations or companies, and it can't be like a social worker asking a question on behalf of someone else. It does have to be the client themselves. That's just how the program is set up. And if you all have questions, feel free to interrupt or ask questions at any time. I don't want to take too much of your time, but I do know I tend to talk fast and throw a lot at people. So feel free to stop me. Another program that we are running is our free legal advice clinics. These are all on Zoom. Members of the public can sign up to meet with an attorney for 30 minutes. It's completely free, again, limited to civil law. And this one has no income restrictions. So if someone needs legal help and they don't know what kind of lawyer they need, or they can't afford a lawyer, they can always come to the clinic. Our registrations are always open. So as soon as we have one clinic, we just open the registration for the next clinic. We do hold the clinics 4 times a year. So January, April, July, October. The clinics are getting more popular. We have about 300. Last year, we had about 300 client registrations. We actually have a clinic coming up April 22nd and April 23rd. And we're already at about 120 registrations for just that one clinic. So you can see how those numbers just keep growing. We have a fantastic team, about 60 volunteer attorneys that help out. It's a nice program that we involve law students and paralegals as well. A lot of the law students and paralegals do our intake interviews for us. So they'll reach out to the clients after they register, get that background information. That way the attorneys are able to make the most of their 30 minutes with the client. I mentioned we can assist any Connecticut resident with any civil legal issue, no income limits. We do have interpreters available for the clinic. And then just a couple notes. We do require pre-registration. That's so that we can match the attorneys and the clients. You know, if a client comes in with a question about a family law situation, we're not going to refer to them to someone who's only ever done real estate law in their entire life. So we really work hard to match the attorneys and the clients.
And generally, you do the conflict checks as well, or?
The attorneys themselves do the conflict checks. So before we send a client file, we send the attorney just the first name, last name, adverse party, city, and the general topic. They do the conflict check and report back. We are lucky in Connecticut. We have very good pro bono rules. So we do have a special rule that the conflict of interest provisions are somewhat relaxed for pro bono work. That rather than having to run like a full scale conflict check, it's based on personal knowledge. So if a volunteer personally knows there's conflict, they wouldn't be able to take the case, but they're not actually required to make sure there's no conflict with anyone else at their law firm, for example. All right, cruising along. Lawyers in Libraries is another of our standing pro bono programs. This program operates in person at 10 different libraries around the state. Each of those libraries has an event once a month. They publish those dates way ahead of time, so someone could look and say, okay, it's going to be November 12th will be the day that it's in Bridgeport. And then we have some volunteer attorneys go, and sort of similar to the clinic, they meet with the clients there in person at a local library. We do find some of our clients really prefer that in-person, face-to-face interaction with an attorney. Similar to the clinics, these are not asset or income limited. Anyone can participate. We do require pre-registration, again, limited to civil law. You'll find that's true for all of our programs. Like I said, we don't do criminal law. And this one's kind of neat because between the 10 different locations, and then they're each having an event once a month, that's about 100 opportunities a year for people to get help. So they can go to a library close to them. They don't have to travel too far. For those of you that do math, you might notice there are 11 libraries on that list. That's because Hartford will be opening soon, but we're not there just yet. All right. Next up, I wanted to mention our CBA Pro Bono Connect program. I know some of you are familiar with this program because we worked with various legal aid organizations to partner with them on this one. This is our direct representation program. So for this one, unlike the clinics or the online question and answer one that are sort of that small bite. This is full representation. Someone's going to court with you, someone's going to a hearing with you, those types of things. And so the way we've set up this program is we offer free on-demand training to attorneys that want to help out. So they take a pledge that they're going to take on a case. We've got a library of 17 on-demand trainings in topics that are in critical demand in Connecticut. So things like what you see on the right there, housing, family law, immigration, veterans benefits, and 13 more that I couldn't fit on the slide. So people volunteer through us, we give them that free complimentary training, and then that's where a lot of your organizations come in, that we would then refer those volunteers to a legal aid organization, or now these days to ConnecticutProBono.org, where that volunteer can then go take on a case and directly represent a person in need. Okay. This one is subject specific. We do have a standing bankruptcy pro bono program. You probably guessed from the title because you're all really smart people, but this does deal with people who are having bankruptcy cases. Anyone who can apply through Statewide Legal Services, who we've partnered with for this program. And then we have about 30 or 40 attorneys, 35 attorney volunteers for this one, who then represent the indigent clients in their Chapter 7 bankruptcy cases. Nice thing for the volunteers about this program is it does satisfy, in the federal courts, there is a mandatory pro bono rule, and this program would satisfy that pro bono requirement in the federal courts. So the way that's structured, the CBA handles the attorney recruitment, screening, the training. Statewide Legal Services is wonderful, and they kind of handle the client applications, client eligibility screening, and then sort of the case matching after that. We do have reimbursement available for attorneys through that program. So any of our attorneys that volunteer can submit an application to be reimbursed for expenses. All right, I think this is the last of our standing pro bono programs. We do have an emeritus pro bono program. Again, we have those great rules in Connecticut that really encourage pro bono work. And we do have a special rule that says attorneys that are retired or licensed out of state can do pro bono work in Connecticut. So this is our way of sort of capturing that population and letting them do pro bono work. The way this program is designed, it's essentially a custom matching program, a little bit like Match.com, but with less hooking up, I hope. So someone who wants to volunteer reaches out to us. We actually have a conversation one-on-one with them to find out their interests, their availability, their experience. You know, do they prefer in person? Do they prefer remote? What things do they already know about? And then we would match them up with either one of our existing pro bono programs or a different pro bono program through another organization so that they can volunteer. You'll see the second piece of this is a partnership we have with the Connecticut Judicial Branch that we do help with the small claims volunteer attorney program. I don't see Roseanne here today, but Roseanne Rush, oh, there you are. But she does just an amazing, amazing job running that program. And we do try to send her some of the emeritus volunteers when we can, make sure that those can continue. The small claims volunteer attorney program probably shouldn't be here because the judicial branch does most of the heavy lifting, not us. But it is a fantastic program. It's at 3 different locations, 3 different courts in the state that each have an event about once a month where members of the public can come. They meet with a lawyer. The lawyer's not actually going to court with them. Instead, they're providing guidance and helping them with their strategy before going in on a small claims matter. So that's 36 events per year where people can get help with their small claims issues specifically. In addition to our sort of association-wide standing pro bono programs that are going on sort of all the time, we also have about 70 sections and committees at the CBA. In short, the CBA is very big. And a lot of those sections and committees do their own pro bono programs too. So I just tossed up a few examples. There's other sections and committees that do pro bono too. But our Young Lawyers section holds an annual pro bono fair and golf event each October. You know, some of you and your organizations have participated in that, and we appreciate that. Our Young Lawyers section also issues a challenge each year to their members to do a certain amount of pro bono work. I believe they're trying to hit 1,000 hours this year. Yeah, okay. So the 1,000 hours, just their Young Lawyers Executive Committee. Our LGBT section just this year started running a brand new clinic for individuals in the LGBTQ plus community to deal with some of the issues that are common to that community. So things like name changes, second parent adoptions, maybe harassment that they're facing. And so those clinics are now up and running as well. For many years, our estates and probate section has done an event where they create wills and do estate planning for veterans. So they have those events. And another sort of more recent one is our executive committee recently started a disaster relief legal assistance hotline to help people who were impacted by the August storms last year. Those storms were a federally declared disaster. That project has now wrapped up, but hopefully we don't get any more natural disasters in Connecticut. If we do, we are ready to restart that program anytime. So that's kind of our pro bono programs. I did mention there's a lot of different things we do on the access to justice front. So I wanted to talk a little about our lawyer-client fee dispute resolution program, which is a really long title. But as I mentioned, it's a free program we offer. It's open to anyone in the public, lawyers and clients that have any disagreement about how much the client owes or how much the attorney charged. And we've made the program absolutely as easy to use as possible. No, you do not need any legal knowledge. You do not have to have a lawyer to use the program. Some of the steps that we took are, instead of having all different motions that people could file, we have one request form. If people want to make any request at all, they file their one request form and just say what it is in plain language that they want. And that's worked really well for that program. We do offer mediation, we offer arbitration. We have about 25 experienced mediators and arbitrators. And they are experienced, but our program committee does make sure that they're only using neutrals that have done like at least 5 to 10 years as a neutral. So not an attorney in representing a party in arbitrations, but actually helping resolve disputes. And so that is a nice alternative to having to hire a lawyer. You can just come to our program to resolve those disputes. I mentioned that we're very involved in the legislative front on access to justice. Just a couple examples of that. So going back several years, the CBA took on a very, very active role in pushing for the right to counsel legislation. I think most people in this room are familiar with that, but that did give a way for individuals to have free legal counsel before being evicted. The CBA was also one of the proponents of the rules that I've already mentioned, allowing out-of-state attorneys and retired attorneys and in-house counsel to do pro bono work here in Connecticut. This year, one of our big activities is we've been working towards trying to get MCLE credit for pro bono work. So our pro bono volunteers often tell us, I learned more through these pro bono cases than I learned in 10 years of practice as a lawyer. And we'd love to see them get some recognition for that. I know the MCLE Commission was also simultaneously working on a similar proposal, which we're fully supportive of as well. And then just more generally, our pro bono committees and Legal Aid and Public Defense Committee regularly propose and support legislation to narrow the access to justice gap. And then finally, and I promise I'll stop talking soon, one of the other things the CBA does to support access to justice is we do raise funds for access to justice. We do regularly encourage all of our members to donate to one or all of Connecticut legal services providers. We have a link on our website all the time. It's always there, encouraging people to make those donations. We've done social media posts. We've put things in our member newsletter. We've done donation drives. We do a week of giving sometimes where we encourage people to give that money to support not the CBA, but Connecticut's legal services providers. And then as I mentioned, when we talked about the bankruptcy fund, we do have a designated fund that can reimburse attorneys for some pro bono work in the bankruptcy context. So that was a lot. I know I threw a ton at you all at once, but feel free to reach out to me or Lena or Tim anytime if you have questions about what the CBA is doing on the access to justice front, or whether we can help someone that you've encountered looking for legal assistance. Anyone have any questions?
Any questions for Jen?
Well, I appreciate seeing a lot of the newer programs, because obviously I have not been a practitioner for a number of years now that I'm on the judge side, but like, you know, when I was active with pro bono type issues is back when I was young enough to be considered a co-chair of the young lawyer section. But what you said there is right, and that's what I try to encourage my CEO and the attorneys in courthouses. Getting involved is where you're going to learn a lot of things. You're going to pick up things when you're doing the pro bono cases of a type of area law maybe you're not practicing in. And I try to encourage people to join up with pro bono type section, because you're going to learn things from areas of law that you may not be familiar with, because that's who happened to walk in that day or that needed some help. So I appreciate that in what I see here, a lot more formalization of the pro bono process with our association than, you know, maybe 10 years ago and earlier when I was involved in.
Yeah, I think that that the association need kind of a real dedication to it, and putting Jen in this kind of full-time role and dedicating her to this. So it's been a lot of growth in the area. And I wanted her to do the presentation because I want the committees here to know all that CBA is doing, because there might be something you say, hey, we're thinking about this, particularly the pro bono committee, and you know, let's kind of work with the CBA so we're kind of not reinventing the wheel, or we have avoid two parallel programs going on at the same time, and kind of get them working together. So thanks, Jen. And as she said, if you have questions or thoughts where you think it can the work we're doing as a commission can work well with the CBA's existing programs, contact Jen or Tim or Lena. So, okay. Thanks. Anything, Tim, or do you want to add? Or?
Oh, Jen's great, and she gets a lot of credit for our programming, and but it is a huge commitment on the part of the association. Stuff.
Okay. All right.
Tim is very kind, but I do not deserve all the credit. We have fantastic volunteers, and I have some staff at the CBA that helps, and they get the credit for doing all the hard work. I can do the fun stuff like talk to you all.
Yep, that's okay. So with that, we'll move to the updates from the subcommittee. We already heard from Legal Aid, Pro Bono Subcommittee, Judge Stewart.
Just have to unmute myself. All right, so anyone who doesn't know me, I'm Judge Stewart, and I chair the Pro Bono Subcommittee, and a good number of the members of that subcommittee are here today, I can see. As I told you all last time, we sort of look at our charges as asking us to deal with both supply and demand for pro bono services. We've kind of taken a pass on the demand side until the Connecticut Bar Foundation finishes its work. On the supply side, we have been busy the last couple months. We are working on setting up listening tours, and really the main point of those tours will be to go around the state and speak to various groups of attorneys, principally those in private practice and also in-house counsel, to get a sense of, for those who are already doing pro bono or who are pro bono coordinators in the larger firms and those types of positions, what it is that has caused them to be successful. Because ultimately what we want to find out is how we can get more attorneys to do pro bono work, and to get those who are doing pro bono work to do more of it and to take a deeper dive into what they're doing. And we want to create allies. So the point of these listening tours is really for us to ask questions and listen, and not, you know, be preaching at them and saying, thou shalt do more pro bono. It's really to get a sense of what has helped them be successful and what ideas they have for increasing pro bono. It's also a little bit to find out what barriers there might be and what we can do to fix those. But my own personal preference is to focus on the positive and not the negative. So to that end, since we last met, our group has developed some content. In other words, a number of questions that we would be asking, some questions that would go to anybody that we might be talking to, and some that are devoted to particular types of audiences, large firms, smaller firms. We do hope to speak to a number of the past winners of the CBA's Pro Bono Awards, who often tend to be small firms or solos, to find out, how it was that they were able to do pro bono work, and also to meet with in-house counsel to the extent that's possible. We also are working on who to invite, and we hope to do a couple of these before everyone disappears for the summer, to get a start, get a sense, and then when we resume in the fall, hopefully we will learn something from doing one or two of these in the mid to late spring. The other part of our group is principally working on developing a one-stop shopping type website for both the clients and the providers, the attorneys, to be able to go on, and in the case of the lawyers, to find a pro bono project that they can commit to and accomplish. So our committee members have divvied things up. They've been looking at other states' websites, some of which they thought were very good, some of which they didn't think were so good, but they are developing a list of attributes that they think are very positive, with the notion of helping us either build on one of the state's websites that we already have, like ctprobono.org, or to perhaps start from scratch, although that would obviously be more ambitious. So that's what we've accomplished in the last couple of months, and I will prepare to entertain any questions if anyone has any.
Have any questions? Let me just say that in terms of the listening tours, our plan is to kind of meet with larger firms in Hartford, New Haven, Fairfield County, Waterbury, but in areas of the state where there are large firms, Windham County, Collin County, for example, we would meet with the regional bar associations. If there are people who are interested in doing these tours or helping out in more remote parts of the state, whether that be in, I have Collin and Windham County covered since I live out that way, but the Danbury, the northwest part of the state, the valley, please reach out, let us know, and we'll get you involved in doing and helping out with one of these listening tours.
That would be most welcome. I don't know that everyone's going to necessarily appreciate me parachuting in from New Haven and from a big firm background. So anyone who is out in those parts of the state that aren't necessarily the three largest cities, very welcome to get your help. And even if you are one of those larger cities and you have connections with particular firms, we'd appreciate your help.
All right. Thank you. The next, the self-represented Access Issues Subcommittee. Judge Demiola was not going to be here today, so Ty's going to do it, right?
Yes.
Yes, good.
Thanks, Justice Brennan. So our subcommittee meets about every 5 to 6 weeks, and we just actually had a meeting a couple of days ago. We've had 3 since the last full commission meeting. So as we mentioned, I think earlier, our focus has primarily been housing and creating access through different modes for housing defendants primarily. So the thought is that if we come up with some pilot programs, we might be able to expand into other areas, but initially housing. So we're continuing to look at how to improve and create resources for people coming to court. A lot of the focus is meeting people where their needs are, which in housing tends to be their visit to court, and they have to show up with filing pleadings and cases get involved. So our couple of main areas of focus and what we've been discussing: use of court advocates and also plain language. And we did have a visitor to our subcommittee meeting. Zach Zarner from National Center, who's also participated as presenter in the full commission meeting. And he joined our subcommittee discussion, shared information on other states, and also presented information on improving plain language. So we have a few working groups within our subcommittee and a couple of areas of focus that they're managing. Again, court advocates in plain language, and they've had their own meetings on those topics. So the court advocate discussions, I think we spent a lot of time on. And it's included ideas of lawyer for a day, volunteer attorney. Obviously, we have the volunteer attorney programs, but creating a little bit more robust and hopefully more volunteers for that program. Use of law students, use of retired attorneys, that's kind of a common theme here. Undergraduates, not necessarily law school students, but even undergraduates perhaps who are looking or interested in law school. Anybody who could serve as a navigator. There's a ton of different roles. It doesn't have to be per se, legal advice, but it's just helping people navigate through the court system, especially when they're in court and visiting. We talk a lot about the court service centers and the mediation programs that are court-based judicial programs, but this is sort of like additional help and additional information. Our centers have only one manager, so anybody who can help an SRP navigate through what they're dealing with, we'd like to take a look at and enhance. And then also we talked about making space in the courthouses. The court service centers are in every judicial district. They are public spaces primarily used by self-represented litigants who are looking for assistance as well as attorneys coming to court. Some of these centers are very large. Our Stanford Center is huge. We could actually accommodate meeting space for some of these programs and resources that we're hoping to gather and implement. So, any questions?
Any questions? Okay, thank you very much, Ty. All right, and then Judge Spader for the law libraries and law.
Yeah, and we're still working on idea generation. I was kind of honest with my committee that trying to fulfill Justice Bright's idea of having big ideas, not just the usual ideas. It's just I indicate how I'm kind of struggling with what that big idea is. We've discussed a lot of issues, like for example, Dean Bellini's in our committee, and he gave a presentation here about separate pathways to licensure. He also gave that presentation to our committee. But we've also had discussions on how to integrate various law school clinics more with the courts. Perhaps, quite honestly, even adding training to judges on how to work with students. As an example, I tend to take a lot of the cases with the Yale Law Clinic, right, when they're representing parties, because it is a different skill set on how to bring those students along without prejudicing the other parties that are part of that case. It's a different kind of skill set that we're not trained with as judges. So I tend to take a lot of those cases, even if they're civil, family, housing. It's kind of like, oh, law students are in. The presiding judge or the administrative judge will be like, all right, what judges can we have handle these types of situations? Because it's different. And there's been discussions about formalizing a way to work with law schools. And even places like the University of Hawaii, a lot of law schools want to send in students to observe things in court so they can learn things to then work in the clinics. But there's not a formalized process of that. So you're sitting in court and University of New Haven will send in, some of their criminal justice students, but there's nothing happening for criminal justice the day that they send their students in. Or, I deal with a lot, Quinnipiac and Yale will send in people in New Haven to let's find out what's going on about restraining orders. We can see the hearing so that we can get better advice when we're helping people do the restraining orders. But they send their class in on a Tuesday where there's no restraining orders being heard that day. So kind of trying to figure out from all the different courts, what is your schedule so that the schools can have a better experience with their students in having the experiential learning to have a better process to educate clients that they're trying to help. We're trying to determine underserved areas from legal aid societies and where we may focus students and interns and young attorneys to have greater positive impacts on our legal communities. The law librarians have been working very well with putting together informational issues to help students, but trying to find those underserved areas where there could be some assistance. So those are some of the issues that we are working on. Not sure what our next meeting is. I know it's in a few weeks. I should have the schedule close, but we'll have some good ideas for you for conference next year.
Great. Thank you. Any questions for Judge Spader? Anyone from the committee have anything else they want to add? Okay, thank you. So a couple other things. I'm going to skip the legal aid symposium for a second and go, since we're talking about subcommittees. Future Access to Justice Conference, Judge Rapillo, is anything that you wanted to add on that?
Really just briefly, our goal is to put the conference on sometime in May of 2026, probably at the LOV. We've started talking about a structure for it. I think we really are waiting to see what the projects coming from the subcommittees are going to be before we set, is there going to be a specific theme other than highlighting the good work that's being done and kind of what the structure of the day looks like. We're hoping it's going to be some sort of a speaker or panel, breakout sessions for the subcommittees to highlight the work they're doing. And we hope the day ends with gathering people back and that we'll have a specific ask for them, whether that means that there's a pro bono fair going on at the same time, or whether there's specific asks to the audience from the subcommittees. That's kind of the general structure that we've come up with at this point. But we're waiting to be informed by all the good work everybody's going to be talking about in September before we put the rest of the meat on the bones. And if anybody is interested in working on this, we're certainly open to having more folks. We're going to schedule our next meeting sometime after today.
All right, thank you. The last thing that was on the agenda was just a review of the legal aid symposium that took place last week. I think maybe a majority of the people here were at that symposium. At least a lot of people were for at least part of it. I was on the first panel, and I think overall it helped again get people focused on kind of where we've been in legal aid and where we are now and kind of where things are going. Obviously, the federal landscape is a little bit different now, and trying to figure out how we all fit in on a state basis in that federal landscape is challenging. But it was an encouraging symposium and well attended. I feel like I'm talking to people who were there, so I don't know if there's anyone else who has anything they want to add about the symposium or any questions anyone has about the symposium. So, well, thank you all for who attended, and it's all kind of dovetailed with what we're doing here. So our next meeting will be in October.
Oh, no, Thursday, June 26th.
Oh, right.
Yeah.
Thursday, June 26th will be our next meeting at 2 o'clock. And then that'll be our last meeting until the October 1st. So, okay. Does anyone else have anything else they'd like to talk about today? None. Is there a motion to adjourn? So move. Second. All right, all those in favor, say aye. Aye. Any opposed? All right. Thank you, everybody, and thank you for the discussion. We'll resume that again. I think although we'll have a meeting in June, we'll put the discussion about the summary process over until this October 1st meeting. Okay.
Thank you. Thank you.